So going to do the wording of this Parliamentary Papers Act 1840, which is I absolutely love this act. It's a absolutely brilliant and amazing piece of legislation written in common law, made to be used like in courts in common law, but it's basically to do with criminal and civil charges, right, and not being liable to them, but only for summary offences, right? Not for indictments, but nonetheless, it's not, the act itself is not parliamentary privilege, but it's made to be similar to it or like it, but instead of it. So it's kind of just like a sort of little act of law, which is a little bit like parliamentary privilege, but it isn't parliamentary privilege. It's like instead of it, like a replacement, and you get a certificate. You're meant to get a certificate from Parliament, from the Speaker or a clerk, or from the Lord Speaker in the House of Lords, right? And it's meant to protect you, but it's to do with Parliament, right? I mean, there's no other, there's no other argument to make about it. It's in connection with Parliament, right? If it's not in connection with Parliament or something to do with Parliament, then it's not relevant. But if it's something to do with Parliament, it is relevant. Now, what the modern MPs are trying to make out is that, this act is only for them. It's only especially for if Parliament have made an order or some kind of judgment that something has to be published, and then it's protected, right? All to do with their ultimate control and orders, right? But this is the thing, every single petition in history that exists in the history books has been ordered to be published by Parliament, right? All of the journals reports. So the entire catalogue of Parliament, which has been ordered to publish, and you see the National Archives deal with all that. But yet people are worried about copying them and publishing them, right? Because it's all been put onto ProQuest, and ProQuest have got a policy. But how can ProQuest prosecute you for copying it or publishing it when you're protected by this act of law, right? So it's kind of ridiculous. But ProQuest are an American company, and they provide all the information worldwide, right? All around the world, to universities and things like that, and make a business out of it. So it's not that much of a big deal that if the policy didn't apply to England. But National Archives are meant to be exempt from it anyway, their policy, right? But if you're paying people to do research for you, and they've got to make copies of the documents and so forth, it comes into effect there because you're duplicating things, right? But you can't be prosecuted. So, again, it's these policies which are kind of taking over everywhere and seem to be overriding the law itself, and then no one will do anything because, they say, no, we can't do that policy, right? And it's like people who've got doctorates in law or professors, and they're all under this policy regime, and I'm like, just a minute, the law says that you can do that, so why won't you do it? I have to get permission. And but that's the whole point in the law. But anyway, right, so apparently we still haven't established if there's ever been a certificate issued, ever, because in the Stockdale Hansard case, they made this act as a result of that case, and this act was not actually enacted and put into effect until quite a while after that case, at least 12 months, I think, or something like that, around 12 months or longer. And there was this other case called Harlow versus Baker, and some internet source said that they used the certificate, but they actually didn't, because a plaintiff brought a case against Harlow who was privileged, and he was told to withdraw the case, and it was normal privilege. It wasn't in the courts, it was heard in Parliament, so they didn't use the certificate for that. And then there's all those case studies in the parliamentary, the History of English Parliament book by Carl Wittke, the American book, which gives a lot of these case studies from sort of like 1800s, early 19. I think they're like mid to late 1800s, possibly early 1900s. And they all say that, you know, there was lots of court decisions made and precedents that you didn't need a certificate from the Speaker. You could just use this act of law as it is, and if you're eligible for it. But then like the judges judging it, but not Parliament, I suppose. But apparently, they decided that, you know, this act was applicable without necessarily needing the certificate, right? And maybe that's why that, you know, there's never been any issued. But this type of act is what they base things like, you know, the Copyright Act 1911, Section 20 on. They base it on things like this act. And the probably the Public Meeting Act as well, 1908. They were knocking out all around. They were really up on civil rights and, like, you know, the usage of Parliament around sort of like, you know, the mid to late 1800s, because everyone was doing petitioning, right? You should see the number of petitions compared to how many in the 1990s. There aren't hardly any, right? And it was just the type of laws that they were doing just towards the end of the 1800s and the start of the, like, very early 1900s, that they were, like, 1911-ish, they were really, really, really into their civil rights and political liberties. Obviously not for election laws and stuff like that, but for petitioning and public meetings and things like that. Obviously, election laws are all regulated a lot more than this public petitioning is, and, like, you know, private bills and things like that. But anyway, so gonna just do this because they call it the Parliamentary Papers Act 1840, but this is the proper title for it. So it's called An Act to Give Summary Protection to Persons Employed in the Publication of Parliamentary Papers. Now, it doesn't actually say anything to do with who's giving the protection in the title or who should receive it, right? It just says persons, right? So persons can be anyone, right? It can actually be anyone. Now, you've got to read this now when you're sober, right? When you're sober and you've got a dictionary with you, so you can get the dictionary out and check what words mean actually, you know, to people in the 1800s who are extremely intellectual people, right, in Parliament, like Denman, right, Baron Denman, right? And you got to read this word by word, right? So this is an act of law, right, to give summary protection. So that is actually protecting you from summary proceedings, right? So as long as it's not an indictment, this is actually to protect people. Why would you want to protect people from summary, you know, proceedings if they've done something wrong, right? Why would you want to? So protection to persons employed, right? Well, employed, you don't necessarily need to be being paid to be employed, right? You know, it's easy to read this and think, automatically assume, right? Because the main time you use the word employment in modern times now is if you're working for someone, right? Right? You know, if someone's giving you money to do a job. But the actual word employment in the dictionary on a sober day when you're not drunk and being open-minded without being trying to have a constraintive or restrictive you know, way of thinking, means persons put to use, right? Persons who are put to use for a purpose, right? People who, like, you know, you can employ. In fact, in the dictionary, you know, it even suggests that, you know, like if you pick up a hammer and you know, hammering a nail in, that you're employing the hammer, right, to put the nail in, right? if you have a volunteer group and they're all delivering flyers for you, right? Voluntarily, they're being employed to deliver the flyers, right? It doesn't necessarily mean that they are receiving money for doing it, right? That it's like that they're being paid. It's the aspect of it that is being put to use, right? So to employ someone is to put them to use, right? To put many people to use. If you employ people to build an airplane, right, you can employ people to put up a tent. But the meaning of the word ended up getting reduced or constrained, and people only started using it if there was money involved, right? If they were receiving money, they was only being employed. But it's not the money part of it. It's the part of the act of doing that is that they are set to work, right? Set to work. They're set to work on something. They're put to use for something, right? And therefore, the connotation of it in linguistics does not necessarily have to have a financial reward of attachment to it. And that's just what it is in the dictionary, right? And therefore, it's open that the primary, interpretation for employment is that if people are being put to use to do something, right, not necessarily that they're receiving money, right, employed in the publication of parliamentary papers. Now, publication, it doesn't necessarily have to. Publication doesn't mean that you have to have a printing press, right? It's only someone who's got a printing press. It's only someone who's, making ink copies in some kind of machine, right? The word publication, and primarily when you're talking about parliamentary law, referendums and elections, right? In modern law, and I'm not suggesting that was the case here, but publication under actually parliamentary legislation and parliamentary procedure means to make available to the public or a section of the public in whatever form and whatever means. So it means to make it available, it's to make it available to people, right? You're making something available to many people, right? It doesn't necessarily need to be by ink, because now, you do it on your mobile phone, right? So it's just the process of, things being made available to groups of people, or large groups or small groups, or the general public, right? But, just being made available, to obtain, right? That's publication. That's why, ProQuest are trying to stop people from, copying information from their database, right? Because then they're making it available to other people. And this is why, some people don't want to copy it, but, there are all those petitions in the archives have been ordered to be published by Parliament, right? So they fall under this Act, right? Employed in the publication of parliamentary papers. So papers actually are papers definitely is something physical, but remember at the time in the 1800s, right, everything was papers because that's all they had, right? Everything was in writing, ink and paper, because they didn't have, mobile phones or digital screens. I don't even know if they had the telegram at that time. They might have just had the telegram, or I don't know if they had the radio or not. I'll have to check the date on that. Definitely I didn't have the TV, radio, right? So parliamentary means something to do with Parliament, right? Now, if you get Erskine May, the book, and put it on the table, right? Get a copy of Erskine May on the table, and the title of the book used to be the Law, Privileges, Proceedings, Usage of Parliament, right? Now they call it Parliamentary Practice. But if you put that book on the table and say, right, well, it was, it is, what's this book about? Well, it's about Parliament. It's about the proceedings, usage, and processes of Parliament. So you could say, well, is everything in this book fall within Parliament? You know, it concerns Parliament or something to do with the proceedings, processes or usage of Parliament. So surely, right, parliamentary papers, this should mean you see, this is how you read this with a, you know, not a constraintive interpretation, but by no means you know, a fantastical, exaggerated interpretation. We're talking about like a modest, but, you know, not so heavily constrained interpretation for which some use could be made out of it, you know. So therefore, when I'm reading this so this act of law, right, is to give summary protection, right, to persons, anyone, put to use in the making available to, you know, people of parliamentary papers. So anything that is, you know, giving information or knowledge or something to do with, you know, processes or whatever in connection with Parliament, right? I don't know how you could dispute that. But it definitely does not, the title of it gives no indication or restriction that it is only authorised persons who make orders in Parliament or have some sort of judicial capacity or authority can say what can and can't be published, and those are the only things which are protected, right? Does not say that at all. And only, you know, particular persons who have got a large printing press and who are particularly making books. It's absolutely, it does not say that at all. So let's go into the wording of it. And by the way, I've got the original version here, right? Because I know the newer version's got some alterations in it to do with, like, you know, the loudspeaker and the Broadcasting Act 1990 and, you know, like adding pictures and sound to it and modernising a little bit. And also, like, the Clerk of Parliament and the things like that, right? Now, so let's do this wording, right? And let's see what we can make of this. So, whereas, what's a great word to start off a proper act of law with that? Whereas it is essential, so this is really important now. Why, you know, that's quite surprising to say that it's essential, because this is about wanting to protect people who might have charges against them or cases or suits, right? You know, possibly criminal or even civil, right? Why would you want to protect people if they've misbehaved or been naughty, right? But apparently this is essential, right? So this is important. Whereas it is essential to the due and effectual exercise and discharge of the functions and duties of Parliament. So we're talking about functions and duties of Parliament here, right? This is what it says. The functions and duties of Parliament. It doesn't say some functions or some duties. It says functions and duties of Parliament. So if you get a book, Erskine May, and put it on the table, and not the new one that says parliamentary practice on it, the actual proper Erskine May book, right, which was, Erskine May did not publish that book till 1844, I don't think, right? So this is 1840. This is 4 years before Erskine May even publishes that book, right? And he entitles his book, The Law, Privileges, Proceedings and Usage of Parliament. The Law, Privileges, Proceedings and Usage of Parliament. That's the title of it, and it doesn't say usage by who, right? You know, because you can introduce private bills into Parliament. So, would you say that the words of functions and duties of Parliament would you say that that could be synonymous with or reflect the title, the law, proceedings, privileges and usage of Parliament? Would you say that the functions and duties of Parliament are possibly, the same thing? Although duty, duty could be an obligation, right? Functions and duties of Parliament, and to the promotion of wise legislation, right? The promotion of wise legislation. That's quite funny. So that's actually making laws known to people. Could be the 1688 Bill of Rights, right to petition, Could be the Tumultuous Petitioning Act, but, making the promotion of wise legislation. But obviously, if you are introducing a private bill, right, you might want to promote it because you might want to get some sponsors on it, and you might want to get it voted through Parliament, and you might want people to back it, right? The promotion of wise legislation. So, promoting, does that suggest to me that, it might be promoting a private bill before it's been passed, before the bill's been passed? You see, in the standing orders, in the older ones, which I've got now, there are whole sections on private bills. And those private bills have got to be put in the newspaper. They've got to be published. If you try to get a private bill through, you're required to publish it in the newspaper. It must be published. The newspaper can't say, I'm not going to publish it, right? They've got to, right? The standing orders say that it must be published in a newspaper, right? So promotion of wise legislation, surely if it's good law and you try to get it through, is that the promotion of wise legislation? People try to get private bills through Parliament, when they're introducing them and so forth. And what about if you're petitioning for something, how are you going to get the signatures? You're going to promote it to get the signatures. So these words, the promotion of wise legislation, that's not just Hansard. Again, Parliament ordering Hansard to be published. Hansard's not legislation, is it? It's just the record of Parliament, what was said and done, the proceedings of Parliament, right? It's not a bill. It's not law. It's not an act. Not promoting legislation when you publish Hansard. Although you can read about them debating the legislation, but it itself is not legislation, right? Promotion of wise legislation that no obstruction or impediment should exist to the publication of such. So publication is being made available to the public. This needs to be made available to the public, right? Or a section of the public, right? No impediments. No impediments should exist. Well, we've got some impediments now with the e-petition service, right? The e-petition service, when you run public petitions on there and collect the signatures, right, it's not even regarded as being received. They haven't even actually received it. It's not even been officially acknowledged that they received it and that, it's accepted to have been laid to them, and put down in the votes and proceedings until it finishes the 6 months, right? But yet they are impeding us from sharing it, from actually promoting it, for promotion of our request for certain legislation or laws to be made and changed, just similarly to promoting private bills, but public petitions, right? And this is the thing. I think this is what in America, in the United States of America, what the First Amendment, the freedom of the press, right? No impediment to the press, no impediment to publication, no impediment to it being made available to the public at large or a section of the public, right? But yeah, we have got an impediment now. We have got an obstruction because that team, they won't publish anything, you know? They won't even let you share it. They won't even let you use that website to share it. And who owns that website? The taxpayer have paid for it. We're paying for the service, but they're not letting us use it, right? Is it that no obstruction or impediment should exist? Well, that is definitely a absolute kick in the balls, isn't it? From what we've gone from no impediment should exist to now, you know, you can't share anything. And remember, there was the Tumultuous Petitioning Act at the time, right? But you could go into the court and you could get the grand jury or consent, you know, for your 20 signatures. And a lot of people, this is when you get the Herbert Broom book, Constitutional Law in relation to the common law. And he's talking about, like, people didn't respect or regard the Tumultuous Petitioning Act very highly because most people thought that it was an implied repeal because after the 1688 Bill of Rights, everyone's got the right to petition, right? But the Tumultuous Petitioning Act seems to put some sort of impediment on it. But if you go in there, how can you argue with the judge if you're actually going to the court to get the consent? If he doesn't give you, we'll say, well, we've got the right to petition. Everyone has, you know. You could even give him a bill of exception, you know, to the king and say, well, actually, you know, the Bill of Rights says that everyone's got a right to petition, but apparently they're not going to give us the right to do it, right? So you could have him. You could actually challenge the justice if they didn't agree to it. And I think that's what it was happening with the suffragettes. They'd actually the Parliament and the courts weren't requiring people to actually go in and get the consent. They just started letting them collect the signatures without it, right? So there wasn't an impediment really because they didn't bother enforcing it except for handing them in, you know, going into the House of Commons with the petitions in large numbers or approaching the King. They were really keen on enforcing that. But that's not actually collecting the signatures themselves or sharing it, you know, by word of mouth or post or print or publication. So there's something definitely in that. Now, should exist in the publication of such the... Now, this is where it's actually getting onto the specifics of these documents and papers. What are they or what might they be? So what actually are these parliamentary papers? What could they extend to encompass, right? What could qualify to be these parliamentary papers? Does it have to be handed? Does it have to be printed in a factory, in a bookshop? You know, can it be anything in the parliamentary library, archives, journals that already has been put out by Parliament, committee reports, committee papers, investigations, blah, 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 etc. You know, all the archive history of the petitions which already were ordered to publish. Now, you've also got to understand there was some various processes in the House of Commons, in the standing orders and in the books and manuals, which not many people are aware of. When you gave a petition to your MP, you know, when you've got all the signatures on it and you already shared it, you know, in public, and you might have had it in the newspaper if you've got a lot of signatures, but if you've only got 20 signatures or less on it, then not that many people will have seen it and it will all be based on evidence, right? But this is like if your MP's George Strickland or someone who's never apparently ever had a petition rejected ever. He always basically explained a way for it to be accepted through the rules, or you know, he argued or debated it to the clerk or to the House, to the other members, that, you know, it can be accepted and there is something that they could act on with it, could be done, right? That's interesting because in the standing orders it says that it can be received either by the rules of the House or by established tradition. So it's saying that you don't have to actually use the rules of the House standing orders. So you can effectively ignore the rules, supposedly, and just go by tradition. Well, what is tradition? Well, tradition is, you know, what is the what petitions have been received before in the past, right? All of them, what is the entire archive history of Parliament? What are actually all the petitions? But unfortunately now they're trying to pretend that they don't exist, and that, there's this, they try to reinvent it since 2010, that it's something brand new, and they I don't know, they're just like trying to make out that, it's some, I don't know, this weird team, this absolutely this team that defies common sense and logic. Basically, if you can get a bunch of unelected persons who no one knows who they are to understand your petition without even consulting you on it, and in their opinion, to what they think, which apparently is not based on any known rules that I know of, right? They've got this weird policy that, two members of the Parliament have signed, which defies everything else, right? And apparently they don't actually have to comply with any legislation yet. The observation of due process of law says that the whole community have a right to convene, to put their the signature on or whatever, or consent before the king comes and collects it, right? There's no impediments in the observation of due process of law, right? The only impediments were introduced in 1661, but then ceased officially in 1986, right? So it was a period. And remember, at the time this act was going, they didn't even think that 1661 act was much of effect anyway. They thought it was a bit of a joke. So, right. Anyway, so what are these documents? Oh yeah, I best not forget. I was just going to say, George Strickland handing the petitions in. Yeah, so look, if it was of a judicial matter or something where you could have like an emergency debate where other MPs might actually be interested in what was just read out and stand up, or it's an urgent matter of grievance, it can be acted on there in the chamber, right? Otherwise, if it's another matter, not being a private bill, but something else that some other area of the government can deal with, it got sent off to the Petitions Committee so they could find out more about it and then divert it to different areas of Parliament, right? And they could ask for it to be printed. But before that MP sent it to the Petitions Committee and they decided what they were going to do with it, or refer it, if they couldn't find anything to do with it, they actually sent it back to the House of Commons main chamber, and they had to decide what they were going to do with it, right? Or give it back to the MP if nothing could be done. But that's not sending it back to you, because if your MP signed it, it was endorsed, and it's actually, I don't know if it's warranted. I think it's sort of kind of like warranted for, at least for, it was good that, they acknowledge the case, but they just don't find a solution for it, right? But your MP, there was apparently a form that they could fill in. This is before it even goes to the Petitions Committee. They could actually send it to do with the galleries and like you got the public gallery with the press in there. You could actually fill a form in that you wanted the newspaper to print it, right? The MP could do that. The MP had a judicial authority to fill a form in and actually order it to get it to be printed before there was any action on it, before Parliament acted on it, before Parliament made any votes on it, any motion, or the Speaker made an order. That MP could fill a form in and send it up to the press, say, I want this printed, right? That's separate from the Petitions Committee, right, calling for papers, documents and persons to look into the matters that are in the petition, not so they can understand them, right? Sorry, not to solve it, not to like, act on your request, but in order to be able to interpret and understand the petition, etc., and then they can actually send it off to the correct department or someone who can deal with it and might be able to act on it, right? Possibly a committee, or you know, if it might need, you know, if it's legislation or law, you know, obviously that gets voted through by the House, right? But that's so the press thing and the publishing bit of it, well, you could have it down to the judicial authority of the MP. But remember, if it only had under 20 signatures from, I don't know, like some cricket club or something, who knows, whatever, right? It's not going to have been, it wouldn't have been in the newspaper, right? It would not have been in the newspaper. Might have substantial evidence attached to it, right? Well, not, you couldn't actually annex, you weren't meant to annex evidence to them later on by this time, because like it was, the committee called for the evidence, right? But what I mean is like the written evidence, the statement, right? However much, however lengthy a personal statement you want to make on it or what to mention in it, right? It might have only had 5 signatures in it, but you might have a compelling case, right? It's not going to have been seen by a lot of people. And remember, under the Tumultuous Petitioning Act, if you didn't go to the court and get consent, it's likely that, you know, people didn't know about it. So that MP actually at that point could endorse it, sign it, and also fill a form in to get it put in the newspapers, right? And then that would have been the first that the public at large heard about it, right? Now, that's not the Speaker. The Speaker didn't fill that form in. The Speaker does not fill that form in, right? I can guarantee you that. He didn't. He did not fill that form in. Your MP filled it in, and they were in the lobby, and they sent it up to the gallery, and they had, like, press officers in there on a regular basis, like, you know, in Parliament, like, you know, you've always got press officers, you know, at the fucking White House or whatever, you know, McLevy or whatever, right? So that's actually a really important stage. Now, obviously, if you had been to a court and if you had got a consent from a jury and if you actually got, like, you know, 1 million signatures or 100,000 or 10,000 and you didn't necessarily have loads of compelling written evidence, but it was going on strength in numbers, you know, evidence and proof that an entire community wants this or that, or, you know, and you know, etc. You know, like the Luddites want the minimum wage raised or whatever, everyone in the country wants the minimum wage raised or whatever, then it likely would have already been in the newspaper because you were allowed to canvass it to the public yourself, right? But you would have likely got a court order from that court. So there wouldn't have been no impediment to it being put in the newspaper. In fact, I think that those judges, I think it sort of came with the order. When you got that consent and judgment, I'm pretty certain that if you went to the newspaper and they said they weren't going to publish it, I'm pretty sure you'd pull out that court order and say, look, I got a judge, it's been given consent from the court, right? And I'm quite sure that at that point, I think if the newspaper refused to publish it at that point, I think that that's contempt of Parliament because it is misconduct against petitioners. That's actually misconduct against petitioners, obstructing, hindering, etc. So that's here, you know, impediments. This is like, you know, this is like obstructions, right? And obstructions and impediments, right? So I just wanted to mention that little bit about the press and the newspapers and how that would figure into the model of it all. Because remember, there was a hell of a lot of local councils petitioning Parliament at the time, and like the Mayor of London, they were complaining to Parliament about MPs, they were complaining about things that Parliament were doing, putting laws through and acts of law, especially to do with the railways and all that type of thing, you know, and councils wanting more powers. You see, councils are petitioning for more powers, to give themselves more powers, to give themselves powers to make orders and regulate traffic. But that's done by law, right? They don't have powers to make orders themselves to regulate traffic and make judgments until it's enacted in law. It gives them that power, right? And this is where it comes into it now, where these councils are doing all these things like, you know, approving planning permission on building and housing and stuff like that. And, you know, people don't like it, and they don't seem to be doing what the local community want. They're doing what the builders and developers want, the applicants, and they're trying to make out that we can't do anything about it. But we can petition Parliament to make legislation or an instrument to stop the council doing it, or to prevent them from doing it, or to, you know, make it unlawful, or to take the land back, or whatever it is, through an act of law or instrument, right? And the council, if you're actually pursuing that through Parliament, you know, it's like putting a private bill through. The council can oppose it as a body, right? The commonality, the people are collecting signatures and forming a body to try and stop the council from doing something, right? And the council, like, can oppose them, right? So it's not exactly like an appeal, but it's there. And we're currently being impeded from doing that. There currently is an obstruction and impediment from doing that, because the e-petitions team are trying to make out that we can't petition about local matters or issues, when clearly it's stated in the 2010 the local petitions, local government petitions order 2010, which was enacted at the exact same time the petitions committee was formed. The current one, 2010, after we hadn't had a petitions committee since the 1970s, right? The mid 1970s, which says that building and planning matters aren't to be considered as local issues. So how can they say, oh, you can't have local issues on there? It's not to be considered local issues, right? I've just complained to Daniel Greenberg about that, because we're being gypped off, we're being scammed, and I don't know who's instructing these e-petition staff, but they're either retardant, thick, or someone is misguiding them. They don't understand that they aren't actually purely governed by this stupid policy thing they've got. They're acts of law, right? They're not under pure parliamentary practice. It took the petitioning process. Some of it has acts of law in place, like observation of due process of law, and this 2010 order, right? That 2010 order is an act of law that they're blatantly ignoring. And then Gareth Price was trying to make out the Senate, like the clerk of the Senate, Gareth Price, who, like, you know, is the most rubbish clerk in history of England, although he's not in England, he's in Wales, right? A Welshman, right? You know, oh, we can't accept that petition, we can't run that. Well, that's funny, because I had it run in 2015 with Parliament, and now I'm doing a Welsh version of it, and it's practically the same wording, right? So how can it not be possible to publish it? Like, oh no, we'll reject that. You know, there's something seriously wrong with these people when it comes to authority, when it comes to knowledge, intellectual capacity, education. They're uncooperative, and they've been given far too much power, right? And someone needs to put them in their place, and they need to learn, right, that they can't bullshit people. They can't billy bullshit people with their lies and utter bollocks, right? Like, oh, I don't understand what you're talking about, right? The more intelligent you are, right, the higher your education and grade and qualification, the more you understand, right? That means that you can understand thick people. The stupider you are, the less intelligent you are, and the lower grades you've got, the less you understand, right? So you can't understand intellectual, intelligent, qualified people who are, you know, far too brainy for you because you're thick, right? But the way they've recast the whole thing now is that intelligent people can't understand anyone. Unless they're intelligent, right? You know, so, you know, intelligent people can't understand stupid people, right? It's not like intelligent people can understand everything because that's what makes them intelligent. No, you know, miraculously, apparently when these intelligent people are studying the petition archives in the history of England, they're like, oh, they can understand it. Oh, we can understand this. all this information we're learning about the lives of people in history, right? All through the 1600s and 1500s and that, you know, all these, you know, suffragettes and other people, right? All these working class people, right? Oh, they can understand that. Got a PhD in history, right? Oh, look, all these petitions. We're learning so much about the lives of these people, right? From these petitions they got, right? All these thick working class people who couldn't learn to read and write, right? Couldn't even write properly, couldn't even write their signature on there. We're learning loads from this. We perfectly understand them. But hey, look, guess what? It's 2026. Here's Gareth Price, right? You know, he's come out of the arse end of a fucking, you know, graduate fucking degree in, you know, parliamentary fucking practice or politics or whatever. I don't understand what you're talking about. I don't understand this petition. It's one fucking paragraph. It's got 50 words to it. Are you thick? Are you thick? You know, are you thick? Right? It's in English. You know, this is a Welshman, right? Gareth Price, a Welshman, a first prize tomato, right? Thick, blunt thick, brick thick, right? Brick thick. He doesn't learn anything from the petitions. He learns nothing. He learns nothing about the lives of Welsh people because he can't understand what they're asking for. He doesn't understand it. You know, this is the thing. Does he want it in Welsh? Does it have to be in Welsh? This is the thing with these people. Who puts these people in these positions? How they get these positions, right? You know, is it a Labour Party plant? You know, is it a Conservative Party plant? Is it part of a political plant? No one knows. But these people seem to be strategically placed to be, right, an impediment, right, or obstruction. Gareth Price, the obstruction, the impediment and obstruction, that is Gareth Price. The living, breathing impediment and obstruction, right? You know, the e-petitions team, Sean Harris. Although Sean Harris wasn't an obstruction because actually I got my petition published, but, you know, I don't know if he's still working on there, you know. The committee, the petitions committee, the living obstruction, right? The living impediment and obstruction to our casework. Anyway, after that little bit of banter, that actually was a joke, by the way, but partly serious. Right. So, what are these parliamentary papers, given that I've just gone through the newspaper and publication process part of it, sketch that out. Reports. Okay, so reports. Committees do reports. Committees, select committees, joint committees, standing committees do reports. Papers. Now, this is fantastical, this. What papers, right? What it doesn't say. It just says papers, right? So, it's not Hansard, it's not a paper. It's a book. A book is not a paper. A book is a book. So, it doesn't also say newspaper either. It's not a newspaper, right? It just says papers. Now, I'll give it that it doesn't say a petition or a bill, but a petition often is a paper on paper, right? And usually could be more than one sheet, right? So it could be papers, right? And it doesn't actually state at what stage of proceedings, before, during, or after either. So that papers for me is, you know, it's the cat's out of the bag. You know, it's like papers. They're concerned with Parliament, right? There are lots of arguments in committee reports about what qualifies as a parliamentary paper or what is Parliament. But surely, if it is in connection with Parliament or of Parliament, right, and it's been published and made available, then surely it's a parliamentary paper. I mean, what even is the thing with the e-petitions website is that they're not even regarded as received, but they've got Crown copyright on, right? So if it's Crown copyright, then it's HM government and Parliament, right? And it's been made available to the public. How is it not published, and how is it not a Parliament publication, right? And now, since the Broadcasting Act 1990 adds pictures and video to it as well, how can it not be an illuminated screen like in the control of advertisements and local Town and Country Planning Act? What is an advertisement? A representation, a illuminated sign, or an illuminated message. But anyway, papers. That papers part of this is, it doesn't say what type of papers, but they're not reports. Just says any paper. See, when you give your MP a petition and he signs and endorses it, how is that not a parliamentary paper? It's been endorsed by an MP, and then he fills a form in and gets a newspaper to publish it, right? The Speaker didn't actually order for it to be published at that point, and it's not even gone to the petitions committee. That's why that little process and part of it was important, and I read about that in another book, another parliamentary practice book that another MP wrote. Votes, right? So votes. Now this is important. Votes. So this one, votes. Now this is interesting because when you hand a petition in, right, just to your MP, and he endorses it and puts his name on it, and it goes in the petition bag, right, and this is before it even gets referred to the petitions committee, right, and they decide whether they want to order it to be published in full or not, and they call for evidence papers or persons, right. It gets put down in votes and proceedings that it actually has been received by Parliament, right? They get put down in votes and proceedings. So your signature on the petition, right, and the MP endorsement, this is called votes and proceedings, right? Because it's the proceedings of the day, and it goes in with the votes, right? So that's important, because therefore it hasn't actually, come out of Parliament in a book or in a publication or in Hansard or whatever. Now, it's true, right? The journals, when the journals are issued and when the journals are published, but the journal's a book, it's a journal. That's what it's called. It's a journal. It's not a paper, right? The votes themselves surely have a right for the votes have got protection. It doesn't say, that when the journal's, published, only the votes in the journal are protected, right? Or only the report. Well, the reports are separate, right? I don't even know if it has the word journal in here. I don't even think it has the word journal or book. Because Hansard's a book, right? So I don't know why they just automatically assume that, it's just this type of these fancy parliamentary books that, the Speaker orders to be published, or, will order, knock me up some, fancy gold-lined laced books, and you've got the guy on the website with a photograph, opening his nice new box of books that he's ordered. Look, we've got some new stock in the Journal office now, in the Parliamentary Journal office, all this stock, ordered to be printed by Parliament. This is all protected from summary proceedings, right? No, it's it doesn't actually say that it's coming. It has to be coming out of Parliament. This is in connection with Parliament, or in connection with the publication of papers, right? It doesn't say at what stage they're published. They don't seem to be in the modern Parliament, in the modern staff. They don't seem to get their head around someone else can publish it before they actually got hold of it, right? It's when we say it's published, right? When we say say when, right? No, actually, I needed to publish it. How do you think I obtained the 200,000 signatures, right? I didn't just go get them down at the corner shop, It's like I walk around the factory, and I've been walking around the town for 5 months or whatever. What were you doing? Or making it available to the public? How? By my own 2 feet and my mouth, It's like a town crier or something. How did you manage to get all the signatures? Well, making it available to the public and the section of the public at large. I was actually publishing it, leaflets and flyers, printing those out, right? There's publications. It's a petition to Parliament. Is that a paper? Is that a paper? Is it concerning Parliament? Oh well, yes. It's in my left hand, I have a paper, a petition to Parliament. In my right hand, I have a subpoena I'm filling in for the court. Right? Is that a court document? Is that a court paper? Is it subject to the privilege of the court? If someone steals it from you, or opens a letter in the mail, the postman, you got a letter from the court. Apparently, opening letters from the court and intercepting mail is a contempt, right? So is that court document, court papers? Doesn't seem to be the case apparently for Parliament, right? But when I send a letter in without a stamp on it, it still gets there because it's privileged post free, right? Is that a paper? Although I'm not publishing it, but I'm posting it. That's the posting of papers, not the publication of them. Although, if you were posting them to the Royal Mail in order for Royal Mail to distribute them, a big box full of them, then, that's publishing them. Because if you sent Royal Mail a huge box of printed petitions and you paid Royal Mail to deliver them, to the entire village or city or county, like they do for elections, right? Because they're allowed to send one notice for free or something under the election law, right? And apparently this is where, like Graham Moore was complaining, apparently that they didn't deliver his, or they didn't deliver some of them, and Royal Mail tipped him off about it, and he was supposedly complaining it in his case, in his election petition, but not got done about it. If you've got a big box of petitions and they need to be distributed to the public, made available to the public or a section of the public in whatever form and whatever means, right, in separate loose leaf paper, right, is that a paper? And is it to do with Parliament, right? And you're making it available. This is unfortunately we don't get the grace of this intelligence, or the narrow-minded man with the gold-plated books in the journal office, my important papers, it's like, oh, we're very important people. I'm just like a clerk in Parliament, I'm in the journal office, like, good for you, this is the thing. So votes or proceedings. So it doesn't have to be, it can be any or of these. So reports, papers, votes, or proceedings. So it doesn't actually have to be any of these. And proceedings are the processes. So look, what are court proceedings, right? When the court sends you a summons in the post, right? Is that a proceeding? Is that a court proceeding? I would say it is, right? When you fill a subpoena in, like, or a witness form and send it to the court, right? But you're not making it available to the public. You're not publishing it, but it's still a court paper, right? That's proceedings. Parliament's got proceedings. So not all Parliament proceedings are published or made available, right? And particularly, this is when we get back onto the 20 signatures or under, right? So, like 1661, right? Let's say 1670, William Penn, right? William Penn, William Mead. Let's say 1670, right? Let's say William Penn did not have a massive group of people in the street. Let's say that there was just him and a bunch of his friends, like, 15 people, right? And then they're all agreeing to this petition or whatever. Now, then they're not publishing it, or they're not making it available like in a newspaper or anything like that, or to large numbers of people, right? So it wouldn't be published, and you wouldn't be making it available to the public because you're not allowed to, because you didn't have the consent, and you're not going to go for large numbers of signatures because, if you only got 15 people on it, but let's say you've got a strong argument or case, right? Now, when you are getting your friends to sign it, and you're going about to their houses, and getting the signatures, and then you hand it to your MP, that's proceedings. That is proceedings, but it doesn't actually involve publication. You don't have to publish proceedings. Proceedings are published in the journal, right? But you can participate in proceedings, right? You can participate in proceedings that have papers, right? But you don't have to publish them. But they're still protected, right? And also, you can actually argue that because the meaning of publish, it actually says that it's to the public at large or just a section of the public. 15 people could be a section of the public, right, if they sign one petition. So you did make it available to those 15 people who signed it, then give it to your MP, right? So it was made available to the maximum number of people you're allowed to, right? And that is proceedings, right? In order to get it into Parliament to give it to your MP, right? Who could then actually order for it to be published in a newspaper, because he's got the authority and jurisdiction to do that without any further order from Parliament, or they used to be able to. I don't even know if they still do that anymore with them, right? Definitely don't want to do them with my petitions, that's for sure. But anyway, but this is all votes or proceedings. But it doesn't actually say journal. You can't just assume that proceedings in here means that, it means a journal. No, proceedings are the proceedings of Parliament, right? Because that's what Erskine May is entitled. It's the law, privileges, proceedings and usage of Parliament, right? Usage of it is by whoever's entitled to use it, not only those who are voted and elected in there, because otherwise all of the people, this is why solicitors and lawyers are subject to legal privilege in legal cases, right? The solicitor and the defendant and so forth in a normal legal case to a court, they've got all these legislation, legal privilege, certain documents, items, things like that subject to legal privilege. It's all through the normal common law, which you've got the same for Parliament, right? And the stuff needs protecting. So, this is one of the inventions in order to help protect those things through their proceedings, and and the votes and papers and reports, not just journals or just a gold embossed journal book that turns up in a big box with 100 copies in, which the Journal Office clerk's very pleased to receive because the Speaker ordered them from Hansard to make me some nice new books, right? This is the thing. It's not just for them, the clerks and the MPs. It's for put the Erskine May book on the table, read the title, The Law, Proceedings, Usage, Privileges of Parliament. That's what we're talking about. That's what we're doing here. That's why it's all these things: reports, papers, votes, or proceedings of either House of Parliament, right? As such House of Parliament may deem fit or necessary to be published, right? Now, that part of it, right, as they deem fit to be published, that could easily be misinterpreted or misconstrued as to mean, like, in context of, as they're doing their daily work, not in a historical sense or a future sense. But every single public petition in the archives has been ordered to be published in a historical past sense, right? So they're all protected and covered, right, already. Now, what you need to take into account is of either House of Parliament, right? As such House of Parliament may deem fit or necessary to be published. Right. It doesn't actually say who persons. It just says the House, right? It doesn't say the MPs in the House or the clerks deem or the Speaker deems, right? It actually says House. Now, how did it deem it? May deem fit or necessary to be published, right? Now, this is the thing. Have they deemed that things are necessary? Does it say necessary and fit or fit? Doesn't say. It says deem fit or necessary. So it's not fit and necessary, right? So when you've got this thing when, they can decide what's fit to be received, and if they don't want to receive it, then, it's got no value to it and it's worthless and it's not fit for anything, right? It says fit or necessary. So that means that we're not talking about fit. If they don't deem it fit, then that's it. If it's not fit, that is it, right? Because that isn't it. If it's fit, or alternatively, other than them deciding if it is fit or unfit or stick it where they want, if something might, regardless of whether it's fit or not, still be necessary. Is it necessary to be published? Well, this is the thing. Did an act of law make it necessary to publish it? Because in standing orders, right, in private bills, they're all necessary to be published in private bills. All the private bills, even before Parliament have passed it, right, are necessary to be published, right? They're necessary to be. It's necessary for the parties who are presenting them to put it in the newspaper, right? And really, observation of due process of law by law of England is necessary for the community to convene, right, in order for them to, deliberate on, what matters they're going to address to the King or Parliament, right? The whole community. Now, how do you make the whole community aware of it or know about it without putting up public notices around the village, making it available to the public or a section of the public at large, giving them leaflets? They might not all be able to come to the town square on a Saturday at noon with a town crier, right? You might actually, instead, for the whole community, you might walk around the houses and give them it, or get someone distributing flyers to them, or put multiple notice boards around, or go, little boy blue, go blow up your horn, the fields in the cows in the meadow, the sheep's in the corn, or whatever you do, right? This is it. So, put it in the newspaper, right? Put it in the newspaper for the whole community. What community? what is the commonality of this petition? Is it, the commonality of, Little Town? Or is it the commonality of, Greater Manchester, or the commonality of, West Yorkshire, right? What is the commonality that is necessary to be informed about this petition by an act of law, right? So, there's that on there as well. But the Tumultuous Petitioning Act, is there something necessary in there? Well, I think that, look, it's necessary to get the signatures, right? And what's necessary to get the signatures is to publish it or make it available, because if it's not available, then you can't get the signatures, right? I mean, it's not necessary to get loads of signatures. In fact, you had to get consent in order to do it. But that was by an act of law, isn't it? And in fact, it says to put in the hands of 21 more persons. So that act of law suggests that it was necessary. What it was necessary is it was necessary to get the consent. That was what was necessary, right? It was necessary to get the consent and permission, right, in order to get to make it available to the public, right? It was necessary to get permission. So you get the necessary permission. But nothing says that you have to get any set number of signatures. Nothing compels you to get any large number of signatures. Necessary to be published. You see, it wasn't always necessary to be published when if the MP sent it up to the gallery or whatever for the press to publish it. Wasn't always necessary. He did it if he wanted to, right? He might have supported the petition and wanted to publicise it in order to get more interest in it, and hopefully more people might support it or write in, right? It wasn't necessary though. But he got the right to do that, to publish it and make it available. Then it would have been in paper, right? But it's fit or necessary, deemed fit or necessary to be published. Well, it's fit. Another thing on fit is the court could order that it was fit to be published when they got the consent, but that wasn't Parliament. But Parliament made an act of law and passed the act of law that the court could give the consent to do it. So that was, this is the thing, Parliament made a law, right? Parliament actually made a law that it was necessary for the court to deem whether it was fit to be published, and it was Parliament who actually made that law and put it into effect, right? So the House did actually deem it because they enacted the law, right? They made the law and the rule. And whereas obstructions or impediments to such publication have arisen and hereafter may arise by means of civil or criminal proceedings being taken against persons put to use, employed by, or acting under the authority of the House of Parliament, or one of them. Now, it does not say acting under the authority of an MP, and it does not say acting under the authority of the Speaker of the House, and it does not say acting under the authority of a clerk. It says under the authority of the House of Parliament or one of them. So that's either the Commons or the Lords, right? So, look, now this is this really is the gobstopper, right? And this is what you got to understand. When you get, and this, remember, these words were written, right? Acting under the authority. You're assuming acting under the authority, you're assuming. Erskine May, 4 years after this, published a book, and he entitled it, and he was a Clerk of Parliament, remember, The Law, Proceedings, Privilege and Usage of Parliament. Is the usage of Parliament, when you are using it, are you acting under its authority? Well, when you open that book and read it, and you've got all these things like, misconduct against petitioners and so forth, if you've got a right to engage, right, then you are acting under the authority. It's just like acting under the authority of a court, right? You don't need, when you submit a court claim, it's authorised, right? There are stages of authorisation and authority, right? All courts authorise you to be in receipt of their forms, to complete them and make an application, right? That's under the authority of the court, right? That's stage one. You are authorised under the authority of the court to obtain and be received of their forms, and you are filling them in under the authority of that court. They have allowed you to take possession of them and distribute them to people, and you fill them in. That's stage one, right? And you send it to the court, and they determine if it will go to stage two, and they will hear your case, right? It's still under the authority of the court, right? It's not under the authority of anything else. It's not under the authority of the butcher, the baker, the candlestick maker, the fucking bargeman, smoke me a kipper, I'll be back for breakfast, right? It is under the authority of that court that you will receive their papers and fill them in, and then apply, right, if they'll take your case on. But you're, it is under the court's authority that you may receive those documents, right? And you're entitled to fill them in, right? This is a thing. So surely, it's under the authority of the House of Commons that, you've got their Petitions Committee report, and it tells you how to petition Parliament, and it gives you instructions under the authority of Parliament. I have got the 1973 Petitions Committee report published under the authority of Parliament, and it tells me that in order for me to petition Parliament, I must write it out on paper in the following form, as you are now given instructions and informed to do under the authority of Parliament, must be in the form as follows: to the Honourable Commonwealth assembled in Parliament, right? So I'm being given authority to write that out myself, right, from Parliament in one of their publications. They're giving me instructions and directions, right, from the committee report that's got it in there, or even in Erskine May, right? I don't know if Erskine May's got that in it, but it's in quite a few of the books and manuals and things like that, right? Tells you the form. So it's giving you authorization to do that part of it. Just like a court can send you Form N27356, right? You're only in possession of it because they've authorized it to be distributed to people, right? Made available. Or hereafter arise by means of civil or criminal proceedings being taken against persons put to use by one or under the authority of the House of Parliament or one of them. In the publication, being the processes of making things available to the public or section of the public at large, of such reports, papers, a petition, votes, going down in votes and proceedings, or proceedings, by reason and for remedy whereof it is expedient that more speedy protection as well, not just protection, but let's get this sorted out now. Let's not be dragging it out for 10 years. Let's get this protection into effect, right? Should be afforded to all persons acting under the authority aforesaid, and that all such civil or criminal proceedings should be summarily put an end to and determined in manner hereinafter mentioned, be it therefore enacted by the Queen's most excellent Majesty, by and with the advice and consent of Lords. So, spiritual and temporal and commons in this present Parliament, assembled, and by the authority of the same. That part's just describing what the purpose of it is for, right? That part is what is the whole purpose. You see, an advertisement advertising that you're doing a petition, canvassing, letting people be aware of it and know about it is still, they are the papers, the handbills, so to say. The handbills are the papers as well, because the handbills are described in the dictionary, and also you can get them in for like elections as well. You can argue that this applies to an election as well, for the handbills, for the protection of the handbills if you get prosecuted illegally, particularly like in the illegal police canvassing section of the Representation of the People Act 1983, where Section 100 says that illegal police canvassing, the police cannot intervene in election canvassing, but they can for petitioners, because that's in the misconduct against petitioners section of Erskine May, which says that they can't interfere or intervene or obstruct. It's literally identical. The misconduct against petitioners under the law of Parliament is effectively the same as what you've got for elections in Representation of the People Act, right? Under illegal police canvassing, it's effectively the same, but one's in the common law and one's under the law of Parliament. And this actually, this applies to that, and that there's no way that they can say that it doesn't apply to it, because it does, right? Although we'll get into this bit of it here, right? But that was just the explanation. This is for what the purposes of it is. So I'll get into this bit now, right? And we'll see if we can prove me wrong. I'll see if I can prove myself wrong. Lord, spiritual, temporal, authority of the same, that. Right, so now we'll get into what have they called it? Proceedings, criminal or civil, against persons for publication of papers printed by. Now it just says printed by order. So it's true here in the side thing, it says printed by order of Parliament to be stayed upon delivery of a certificate and affidavit. To the effect that such publication is by order of either House of Parliament. So this is the part that's going to try and derail us and throw us off. So it's the first word in the whole act that is challenging my basis, is this order. But this is the side notation. This is the summary of... Right, so let's tackle this then. We're going to tackle this now. There are only 3 side connotations in this act, right? It's a very short act. That's all there is to it, right? And we've done the introduction, and this is like the the bottom part of it's just about where it was. Oh, that's legislation as well, the bottom bit, right? So we've got these three side parts. So this is the part where I think this is the part where the Speaker of Parliament is in disagreement with me, and where the staff of Parliament are in disagreement with me, right? Because of this word here, the word order. So this is now our first obstacle, because it's making it sound like it has to have been ordered to be printed by Parliament, right? And therefore, when you and me write a petition and go around collecting our signatures, that wasn't ordered by Parliament, right? But this is the thing. All of the past and previous petitions have been ordered to be printed by Parliament in the past. So all the ones in the National Archives are all covered by this Act. Therefore, people can copy them without being liable to civil or criminal charges. So the ProQuest policy can't be lawful, right? In England. Maybe it's lawful in America and Brazil and South America, right? But not in England. Although the National Archives say that they're exempt from it anyway, right? Now, so how do we tackle this word order? Well, I got the Samuel Johnson Dictionary here, right? Let's just have a quick order: to regulate, to adjust, to manage, to conduct. To regulate, to adjust, to manage, conduct. To give command, to give direction. So I think that'll be their main, that's going to be the main interpretation on this. So that's definitely, when you say to Parliament you want to use this Act and you want a certificate from the Speaker, and they say no, because the things that you did were not ordered to be done by Parliament, they're interpreting the word order under this, which is to give command, to give direction, right? The Speaker ordered the clerk to go to the cellar and fetch him a bottle of whiskey, right? That was an order. But what we've actually got in the Samuel Johnson Dictionary under order is this. We've got a method, regular disposition. We've got two, right? The second meaning for order is an established process, right? Now that fits our needs. If the word order is established process, right, one of the meanings of order, criminal or civil against persons for publication of papers printed by established process of Parliament, then we're on to something, definitely. Printed by established processes of Parliament, right? Because then that would include your right to petition. Because remember, when Erskine May puts his book on the table 4 years later, the title of it is The Privileges, Proceedings, Law, Usages of Parliament, right? And that's actually perfect for what we want. So established process is a good meaning for order, right? And then we've got three, proper state. And then the fourth is regularity, settled mode. Well, that's funny it says the word mode there, because I think in Erskine May, under petitioning in his very first edition, the very, very, very first edition of Erskine May, the 1944 one, which is available from Cambridge Press, which is the first one I bought because it was cheap, right? Before I got the later versions. It's only quite a short book. Chapter XIX, which is petitioning, he's entitled it The Ancient Mode of Petitioning Parliament. he calls it the ancient mode of petitioning Parliament, which is quite interesting in his 1800s language, which was 4 years after this act, the ancient mode of petitioning Parliament. Now, that's interesting because that word mode is not used very much, except we only really use mode in a modern context. And funnily enough, I find it quite interesting and something to contemplate. In a modern context, in the 20th century or whatever, in the 1990s and 2000s, it's a very rarely, you don't use the word mode, do you, right? Unless you're using some kind of computer game or controller, like, you know, what mode are you in? Like, or like, it's like the Knight Rider, you know, switching to sport, like you switch your car to sports mode, or you switch your car to, like, you know, 4-wheel drive mode. Like, mode is a shift or a change in usage. And that's actually ironic here, because if you think about it, what am I actually doing now? I am selecting the word order and focusing on the word order, and I am looking at Erskine-May Dictionary, and there are different modes of application for the word. There are different meanings to select for the word order. And that's just like having actually a controller or a little joystick or a little button that selects a different mode, right? I'm looking at the word order, and I can actually select a different mode for order, because I can, for the word order, I can put in the mode of method or regular disposition, or I can put the word order into established process mode, switching the word order to established process mode. Now order means established process. And now I'll switch it to proper state mode. And now I'm switching it to regularity, a settled mode. And now I'll switch it to mode 5, mandate, precept, or command, right? I'll switch it to command mode, right? So the word order can actually have different modes of meaning, right? You can switch it to different modes of meaning according to Samuel Johnson, right? So, I mean, wouldn't it be great if we could just keep the word order in the established process mode? Because then, when we're reading this, that's perfect for us, because we can have, civil criminal charges against persons for publication of papers printed by established process of Parliament, right? And then boom, we're straight into Erskine-May. Then we've got the usage of Parliament, right? But unfortunately, the Speaker wants it to be fixed in the word order should be fixed in the mode, which means to give command or direction only, right? Only by the command or direction of Parliament, right? So he wants it in command mode only, right? The command and direction of Parliament mode only for the meaning of order, which is quite interesting. So, yeah, I mean, mode, the ancient mode of petitioning Parliament, to find the word mode in a context from before computer games and electronic devices, to find the word mode, the ancient mode of petitioning Parliament, right, in an 1800s context with no electrical devices, right, is quite unusual, because it's not really a word that you associate with, archaic time or, historical period dramas. The word mode is definitely something that, you usually grow up with, that only means, if you've got some kind of dial or electronic device or possibly a mechanism, like a Meccano set, right? Or I suppose the gears on a drop handle mountain bike, or a drop handle cycle, right, for the road. You could have different modes for the gears, but they don't call them gears. They've got numbers, haven't they? They've got first gear, second gear, third gear, fourth gear. That's really a mode, isn't it? It's like in first mode, second mode, third mode, fourth mode, right? So you can actually do that with words. You can actually have different modes for words according to the dictionary. And that's like, the word before is like in order to, right? Not just in front of. Because like, you can be standing in front of someone, right? And you say, oh, I'm in front of you, but you don't say I am before you, right? But the word before actually has a mode for meaning in order to do something, right? So, by established order. So, we really can, there is something to challenge them on with that order word. And I really think it's interesting that in the Samuel Johnson dictionary, it's got this mode thing. And then it's very, very interesting to me that Erskine May actually calls it the ancient mode of petitioning Parliament, which is quite interesting. To be stayed upon delivery of a certificate and affidavit to the effect that such publication is by order of either House of Parliament. Well, the certificate and the affidavit is really issued by order, isn't it? And there's one more interpretation I've got for this word order as well, which is that when was the order made, right? When was the order? Because every single petition in the archives was ordered to be published by Parliament at some point or other, therefore it's covered by this Act. But does the word order in this little side paragraph, printed by order of Parliament, can it mean legislation? Can it mean that, when the legislation was passed and given assent by the King, is that an order? And printed is to make available to the public or a section of the public. So, is the observation of due process of law, right? Is the observation of due process of law 1368, is that an order of Parliament? Is an order of Parliament that the community will assemble or come together to petition the King in Parliament? Was that an order? And what about the 1688 Bill of Rights, right to petition? And what about if if you've got how do you even know that how do you even know that you can petition and that it exists? I mean, where does it even tell you? How do you even know what petitioning is, right? You see, on the modern e-petitions website, when you go on there, right, have they made an order that page is to be up and that, people have to fill it in? So the presentation of the terminal, the portal, and it being presented to persons to complete and fill in, and you being told to collect 5 signatures, is that by order of Parliament, right? So are you collecting? Have you been given an order to fill the petition in and write the background and summary and title? And are you being ordered to collect the 5 signatures? And are you also being ordered to share it on Facebook, Twitter, Instagram, etc.? When it says share this petition, is that an order of Parliament, right? So are Parliament ordering you to share the petition to make it available to the public by the directions on the website as an order, right? And if that's the case, then when you actually buy the manual of procedure, does the manual of procedure in the public business order? So, when you write, when you print letters and when you write a petition and it can be lithographed, is the manual of procedure that's where it tells you, where a petition, not just in the committee reports, like tells you the form of it or whatever, right? Did the manual of procedure in the public business, right, order you to, print a petition in ink print it with your hand, and you're allowed to make lithograph copies, printed, and distribute them to people to collect signatures, right? Is that an order? Is it an order of Parliament in the Manual of Procedure in the Public Business, right? Or even in Erskine itself? Or standing orders? Standing orders! Is a standing order of Parliament? Standing orders. Although standing orders are usually when they're received. The standing orders of Parliament are when your petition is received, right? But those standing orders have got orders for it to be printed, and if the MP wants it to be printed, to send it up. So that'll definitely cover it for the newspaper when it goes in the newspaper, even before Parliament have debated it. If he wants it in the newspaper, that'll cover it for one MP endorsing it. Standing orders, definitely. Standing orders are orders, but I don't know whether they tell you to publish the petition or not. Oh, they do for private. They do for private bills. Standing orders of Parliament. They order it to be put into the newspaper. It has to be put into the newspaper. So that's by order of Parliament, ordering it to be put in a newspaper, right? So that printed by order of Parliament. Standing orders for the private business. Standing orders for the private business tell you that it has to be printed, right? So that is absolutely 100% certain. So surely, for private bills and public petitions, but at one point it didn't really have much in the standing orders for public petitions. I don't know if it tells you, it doesn't say you have to put it in the newspaper, but I mean, how does it expect you to get all the signatures, right? I mean, how does it expect you, to let people know about it? And remember that, you didn't really have, you had to get the permission, supposedly. I think that, that, you see, this is actually totally well falling into place now that I've bought those old standing orders books, the early ones, because they've got to actually tell you that you've got to publish it and print it, right? And that is standing orders of Parliament, right? Let's check the other side headers. Proceedings to be stayed when commenced in respect of a copy of authenticated report, etc. And then we've got in proceedings for printing any extract or abstract of a paper, it may be shown that such extract was bona fide made. So this is like when the newspapers are the parliamentary journals actually made an extract. Because the parliamentary journals didn't always put the exact wording of your petition. Sometimes they changed the wording to summarise it just for in the journal. Other times they wanted it full, or they wanted it in full. So they're the ones doing the abstract of our petition, right? So when you're out in the streets going, stop the ULEZ, stop the ULEZ, stop the ULEZ, right? And that's an abstract of the actual, title of the petitions. The Stop the ULEZ Charge petitions. It's not just us who are making an abstract of the original petition. Parliament themselves make a little abstract of it to put in the journal because they want it to be all neat and prim, unless it's ordered to be printed in full. So they're the ones doing the abstracts as well, which I just realised. That's another thing that's just clicked in my mind. Such extract was bona fide made. So that's a little bit more to do with newspapers. And then there's this here to do with it not, because this act is not actually privilege. It's instead of it, you've got this little bit at the bottom to say that it won't actually, the order of the court won't have any long-term adjustments or effects to the law of Parliament, to privilege, because otherwise then the courts would be able to set precedents and so forth. Like, when you get a court judgment and it sets a new precedent for the other courts, You're not allowed to do that with privilege, because otherwise the courts would be modifying and changing the interpretation of privilege, and it's privilege on to Parliament to interpret the privilege, right? And also, you've got that the Parliament Act 1911 says that a certificate from the Speaker shall not be questioned in a court of law, but it shall not affect privilege either way. Well, this doesn't affect privilege either way anyway. This isn't privilege, right? You're not using privilege of Parliament with this act. It is an alternative. It's almost kind of like artificial privilege. It is purely common law, and it is, instead of using privilege, therefore it doesn't affect privilege either way, and no order or judgment from a court does. And therefore, these actual certificates that the Speaker issues are actually fully, they cannot be denied by the court. They can't be rejected by the court. The court can't say that they're not valid or they don't apply. It cannot be questioned in a court of law. It must apply. It has to apply. Because it doesn't actually affect privilege of Parliament either way. So I'm pretty sure that 1911 Act from the Speaker certificate is really important in this, and that's why you want the certificate, because you're actually they're ordering the court to cease and desist, to stop, basically. I think this is a good idea, and it's a shame that they didn't actually use these certificates, right? Like they used to do writs of privilege. The 1600s, they got writs of privilege were used, and then they stopped using them with the 1688 Bill of Rights because they said you didn't need them anymore, right? So they weren't using them all through the 1700s. You didn't need them because of the Bill of Rights. But then, after Parliament burned down, and when they're doing all this, then Denman decides that it's a good idea again, right? But they don't really make much use of them, but it's just there. Persons were using this act of law just as it was. The reason why I think it's a good idea is this. If you got prosecuted illegally in the courts, right, you could complain to Parliament at the bar, according to John Tinker in the 1944 report. And therefore, you could present a petition of grievance that, the court's prosecuting you illegally, right? And then you could effectively get the police, sheriff, justice, or Crown prosecutor summoned into Parliament, and then they tell him to stop, or, he's in contempt. And if he doesn't stop, then he gets, arrested or charged. Now, this saves all that trouble, because, if you just go to Parliament and say, I'm getting prosecuted illegally, make them stop, then they give you the certificate, you go into court, and he has to stop, right? That he can't argue with that certificate, he stops. So it saves him being summoned into Parliament, it saves him being in contempt. He just gets a certificate and you stop. You're like, stop. It's easy. It's just that I don't think Parliament want us to be privileged. They don't want to let us or allow us to have the protection, which is scandalous and, it's just preposterous and scandalous. They're not actually letting us use that right to petition, the 1688 Bill of Rights. They're not, and this is the whole thing of the Public Order Act, and the whole thing's been forgotten. And, you wouldn't have had this, under the 1715 Riot Act, when it says that, you've got to be tumultuously, riotously, and illegally assembled. If you're not tumultuously assembled, you don't qualify for that Riot Act, If you haven't got 20 people, but you're petitioning Parliament, you can't be guilty of a riot. Don't matter if you've got, over 12 people or not, right? You're entitled to that privilege. It says in the Act, if you are not tumultuously assembled, it's not an offence, right? So if you've got under 20 people, you cannot be charged with a felony under the Act. And if you have got a court order, you can have a large number of people who aren't guilty of a felony under that Act, right? That's just the way it is. So, they weren't, there was no, let's not be under any misunderstandings at all. So, we'll actually do the main wording of these 3 sections then, and then it's going to be it then, I think. By the authority of the same, that it shall and may be lawful for any person. That's good. Anyone, not just hands and staff. Any person or persons. So that's like not only just one person, but a group of persons who now is or are or hereafter shall be. We're starting to get, it's a bit like Strode's. I'm starting to get like a bit of a Strode's Act vibe now from this. Shall be a defendant or defendants. So this is not just one person, it could be many. So this could be like, the Stop ULEZ people who are all charged with conspiracy, but this only applies to like the promotion and advertising. So I'm not saying that this extends to criminal damage, but under the Control of Advertisements 2007, and the Town and Country Planning Act, what is an advertisement? It can be a representation. There is an argument for, is it a representation and is it an advertisement? And are people making advertisements, out of objects? Like installing adverts, logos, signs, or things to things. We're looking at models, basically, effectively, like, a model. Are you making a model which is a representation and has a meaning? And is it contemplating Stop the ULEZ, right? Because that's under that PACE Act, right? Is it contemplating, giving a legal notice to persons, a legal notice? Are they giving a legal notice, because, a privileged advertisement of matters of course to Parliament is a privileged notice, but this is actually something that I'm disappointed that they're not arguing this out in the courts. They don't want to, because they don't even want, at the moment, they don't want to even acknowledge that is a privilege and that it could possibly exist, and they don't even want to argue, around. They definitely don't. Well, you're not meant to argue it in the court. That's the thing. You're not in the court to argue it. You're in the court to say that, you don't have to defend yourself because there's no case to answer, right? That's why you're there. Otherwise, you're getting into common law and it becomes a defence. If you're trying to argue, right, the Town and Country Planning Act, what is the meaning of advertisement and control of advertisements, Class F, you're arguing common law there. Maybe you could do that in the High Court to just establish a basis that, if someone, what the parameters or extent for a model can be, can you, make a model out of, street furniture or something like that if it's public property? Is that an advertisement? And that's what you can argue in a court, but you won't want to argue it on the defensive side. You want to go into a court and say, look, right, we can make an advertisement out of street furniture, right, and it can advertise a parliamentary cause, right? You can go into a civil court and say that, and if the judge agrees with you and it sets a precedent, then that's it, boom. It's like you can, every time challenge with privilege and you're doing parliamentary cause, then it is acceptable that you can make advertisements out of street furniture, right? You can apply the privilege to that without question or contest. That's I think the stage that they need to be at, but that is like boom, off the page for these criminal. You can't get a criminal lawyer to do that because they haven't got a fucking clue about it. It's not within their training remit or anything like that. You need to get you have to. I don't know whether you need a public law lawyer really, or a civil law lawyer who is Well, actually, you don't really need them to do the parliamentary privilege part of it. You just need to argue under the public law and the Town and Country Planning Act and the control of advertisements that, you can, can street furniture be made into an advertisement, right? Can it qualify as an advertisement? Can they accept that it is an advertisement? And then it just all comes down to if you've got the legal right to do it or not. Like a deemed and express consent type thing. But no one is going into court with that argument at the moment, and that's I don't know why. It's just very strange that no one wants to seem to go in and get all the Town and Country Planning Act out and the control of advertisements and do it. And that's really what we've been wanting to do for a while. But no, you don't want a criminal lawyer because it's got nothing to do with criminal law, really, until you get onto the Criminal Damage Act, and then if you've got a lawful excuse, it's how does the act tie into the defacement part of the control of advertisements? It can get quite complicated. Anyway, so for any person or persons who now is, or we've done this bit, are or hereafter shall be a defendant or defendant, so that could be a group or body, in any civil or criminal proceedings commencing or prosecuted in any criminal commenced or prosecuted in any manner whatsoever. Commenced or prosecuted in any manner whatsoever. For or on account or in respect of the publication, that's making available to the public or a section of the public at large, of any such report, paper. So a petition is a paper. Votes or proceedings, and obviously those private bills that you had to put in the newspaper, that's a proceeding because it's a proceeding under the standing orders, right? For private bills. By such person or persons, or by his or her or their servant or servants. So even people that, the person who's printing the things for you, right? If you're getting loads of handbills printed or leaflets, that protects the person who's printing the leaflets as well for you, Not just printing them if Parliament wants a load of journals printed up, but if you, the petitioner, want your handbills printed up, it extends to the person who's printing the handbills, right? If it's a petition paper, by or under. See, it doesn't have to be by the authority of. It's by or under the authority of either House of Parliament. It is the right of the subjects to petition the King or either Houses of Parliament, and all prosecutions for doing so are illegal. Right? This is what is in the Herbert Broom Constitutional Law book. Right? It's privileged to bring before the court in which such proceeding shall have been or be so commenced or prosecuted, or before any judge of the same, if one of the superior courts of Westminster, first giving 24 hours notice of his intention to do so, to do the prosecutor or plaintiff. So you got to notify the prosecutor or plaintiff as well about this 24 hours, according to this, and such proceeding, a certificate under the hand of the Lord High Chancellor of Great Britain or the Lord Keeper of the Great Seal, or of the Speaker. So it wasn't actually just the Speaker of Parliament who could do this, it was ministers as well. A couple of these ministers, I didn't realise that, because the newer ones, it's like the Speaker of Parliament or the Lord Speaker in the Lords. It could have actually been the Lord High Chancellor could have given it, right? Or the Lord Keeper of the Great Seal. Well, this is in 1840. Or the Speaker of the House of Lords. Oh, it says the Speaker of the House of Lords. Did they have a Speaker of the House of Lords? For the time being, I thought they only just had the Speaker. I thought this was the old original version. I thought they only just added it and updated it to the Speaker later on. I think I might have got that wrong. Unless I think I might have opened. I don't know if this is the original one or not. I don't know if they had a Speaker of the House of Lords. The Speaker of the House of Commons. Just a minute. Or the Speaker of the House of Lords. For the time being, or the Clerk of the Parliament. So the clerk can issue it, or of the Speaker of the House of Commons, or the clerk of the same. The clerk can issue it, which is quite concerning, because it was when I needed to do this, it was the clerk of a normal magistrates court who I got into a really big argument and dispute with, Sam Goosey, and then he ran away after the whole escapade and jumped up the ladder into the judges' circuits and became a judge after being on the advisory committee, and climbed up the ladder, and now apparently judges can't be prosecuted. He's chasing the immunity and protection, right? But yeah, these judges can be called into Parliament on contempt, and they can be removed by Parliament. Stating that the report, paper, votes, or proceedings, as the case may be, in respect whereof such civil or criminal proceeding shall have been commenced or prosecuted. I thought that the first early version of this, the 1941, didn't have the Lord Speaker, because they didn't have a Speaker in the Lords until the Constitutional Reform Act. But I might be wrong about that. But I'm quite surprised, because I thought the first one didn't have the Lord Speaker in it until they actually invented him. So anyway, where we got to now? The Clerk of the Parliaments, or of the Speaker of the House of Lords, the Clerk of the same, the Commons, right? So this is what the certificate should just say, right? I don't actually think that they've got a proper template for these. I think it's just like the fact that they wrote it. It's from them, and they will like just basically write the particulars, and it's authentic. I think that's what the case is going to be with these, right? Stating that the report, papers, votes, or proceedings, as the case may be, in respect whereof such civil or criminal proceedings shall have been commenced or prosecuted, was published by such person or persons, or was made available to the public, right? Yeah, by such persons, or by his or her or their servant, right? So that could even be like, the person that we got to print our petition handbills, right? Or the servants by order, or it doesn't have to, like, okay, right, this is it, right? Right, so all that I said about this side bit here, or having a dispute over the word order, right? In here, right? And this is the dispute with, like, Simon Burton, or this is the dispute with, like, Tom Goldsmith, or the Speaker, or I guess David Lammy as well, right now, right? It says order or under the authority of the House of Lords or of the House of Commons, as the case may be. Well, where's it's not as the case may be for the court that's prosecuting you, because that's their case, right? As the case may be is their challenge against you, right? What you're trying to make out is, as the case may be, right? What is your case, and do you have a case, right? You know, if you are petitioning Parliament and the usage of Parliament, right, you have a case, a cause as a matter of Parliament. This is misconduct against petitioners, right, as the case may be. Exactly as set out in Erskine May, right, you know, all of those things set out in misconduct against petitioners, right, when they're going about their business, if it's to do with the canvassing, right, because this is the thing, right, look, the main part of petitioning Parliament is canvassing, right, and paperwork and canvassing, maybe a little bit of investigation work, but like only, you know, enough to get the information that's in your petition, right? Because then after you've submitted it, the Parliament are supposed to summon persons, papers, etc., blah, 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 under their warrants or whatever, right? If they're going to investigate it further, or like public inquiry or whatever, right? So obviously, you know, to get your information that's on the petition, right? But this does not protect you from criminal damage, right? Like in the sense of like how the police are using like, you know, reasonable force to enter somewhere, and they're covered by lawful excuse and criminal damage, because it is a lawful excuse, right? Like, you know, if you're petitioning and you're collecting evidence, right, this is not for, like, you know, if you had to go and get some evidence from somewhere and you use force to get in, right? I'm not suggesting that at all, because this is for the publication of papers, which is making papers available to the public or a section of the public in whatever form and by whatever means, right? Which includes handbills, which includes advertisements. Now, the modern developments on that, and the modern legislation, which we need to kind of like, does need to be argued in court, right? Although maybe you can argue it with Parliament, you know, as the case may be, is that this Act has been updated by the Broadcasting Act 1990. So we're looking at videos and pictures as well, not just things on paper. And further to that, digital screens, right? You know, like light up advertisements and stuff, right? And messages. But the thing is, in the Town and Country Planning Act, it's got a definition of advertisement, right? And all those things under definition of advertisement when you're canvassing is not just papers, right? And it covers, you know, like those illuminated screens, which the Broadcasting Act 1990, I guess, covers pictures and screens, right? But it says it can be a representation, but also a model or a sign, right? Because a model or models and signs and letters have meaning in them, you know. They have a meaning and interpretation. So it's like got a modern art twist on it, right? Into the inclusion that they're saying that you can have a model or a representation. It doesn't have to literally be in full text and writing if you want a canvas, advertise or promote something, right? And that, therefore, also applies to the Control of Advertisements 2007. In that act, it says you can use the Bill of Rights directly, right? So it's an 88 Bill of Rights, because you can use any enactment, right? Now, the argument is about the installation of advertisements onto public property, which you don't need deeming and express consent for if it's Class F. You don't need deeming and express consent, and it's not defacement, and it also isn't criminal damage to attach them, right? How far can you go in installing models on public property, which is basically, street furniture, bollards, things like that, bollards, street furniture, etc., right? Even ULEZ cameras, right? Can the ULEZ camera have an advertisement installed on it to the extent that, it becomes an advert, primarily an advert, or whatever? This is the question, because you can make a sculpture, like all these weird, sculptures that they make on the beach, like out of metal, and they like move around like sea creatures or whatever, right? There's all kinds of weird stuff you can do. That's the argument. But there is an argument for it. That's the thing. Either there is an argument or there isn't one. It's possible to argue. It is debatable, right? It's within the scope of the meaning of those things. And the problem is that the courts don't like this at all. But it exists. And look, someone made that act. The Town and Country Planning Act was made to include signs, models, etc., because the government needs to use it as well, right? And it's unfair if the government or a corporate business can have a certain type of advert, but then other people can't, because that's not, like in the Human Rights Act, the Equalities Act, or whatever. If private companies and businesses are using particular certain types of advertisements, like models, right, 3D models or whatever, then surely other people should be able to use that same type of advert for a political campaign or cause, and they don't have to pay for it because, it's usage of Parliament and etc., taxpayer funded, whatever, right? So, and then also when you get to like these, signs at the sides of motorways and then all those 3D signs and all that type of stuff, which it seems that money can buy it. If you've got enough money and contacts with the government and councils, money can buy it. But apparently, democracy can't buy it for, the value of X amount of signatures who have signed it, right? Democracy is not free anymore. The big corporate entities are managing to buy themselves whatever they want with the pure spending power of money, right? But we are not managing to fully match them in law, legally, what you're entitled to legally do for free with the pure use of the law, right? Purely democratic power. So, fucking Jeff Bezos puts a digital illuminated board over the motorway, pays for it. It's dangerous, distracts people, but so fucking what? He's a billionaire. He can get the council to do what they want, right? He could probably put a picture of his moonshine over the motorway if he could afford it and get away with it, right? But Roger Hallam can't, because it's distracting traffic and, causing them to stop and, apparently dangerous. But Jeff Bezos can do it with the pure spending power of money, right? But, they won't let the protesters climb up on, over the motorway and, put signs up because it distracts motorists. But, why isn't, Jeff Bezos and whoever's, light up digital boards at the side of motorways and over the top of them, which they've got, apparently don't distract traffic, right? So it's a double standards, and it's all about money can buy courts and councils, but apparently when it's protesters who want to do something democratic and oppose the government, right, they're not allowed to do it, and they're getting done in the courts, and Roger Hallam's been sent to prison because he's, apparently planning public nuisance, right? But it's not a public nuisance when Google are spamming everyone's phones with adverts, slowing down their day, making user-friendliness hindered, because, accept consent, submit consent, accept. Jeff Bezos and Google have got to accept consent and agree to the laws of England, right, which includes our democratic rights. But they don't seem to be wanting to do that with their fucking Section 230 or whatever where they want to stick it, right? So this is as the case. It's definitely as the case may be, and when you get to the words of it, says order or. Now that's a big. This is a huge big or word. This or order or. Under the authority of the House of Commons. So no one had to make an order. But remember, there are standing orders which are already written, pre-issued, that you must do this, you must do that. You've got to publish this in a newspaper if you're doing this process, right? So if that order is not just like the speaker hitting his hammer down and saying, I order this book to be published, if it's like, well, we ordered this standing orders book to be published that says you have to publish this, right, in these proceedings, it's required for private bills, right, then surely, if it's order or under the authority of Parliament, surely you're petitioning, doing e-petitions under the authority of Parliament, surely you're using the observation of due process of law under the authority of Parliament, and the 1688 Bill of Rights under the authority of Parliament, because Parliament ordered the act to be given royal assent, right, for you to use. That's by order of Parliament, right? And this is what, unfortunately, a lot of these privileges committees don't want to entertain us on this. I think that they could have come to these conclusions themselves if they'd have wanted to, but they're obsessively conservative and minimalistic when it comes to this, because they don't believe in our rights and authority and powers. They don't believe in it. Yet, people have hung. There were death penalties, on that Riot Act. There's a death penalty, but it clearly states, right, you've got to be riotously, unlawfully, and tumultuously assembled, which you cannot be tumultuously assembled if you're under 20 people, even if there's 12. You cannot be tumultuously assembled, and, you cannot be tumultuously assembled if you're walking around with an order from court, right? Because it says that, you've been given permission and consent. That's an order to have, right? But they repealed that act. As the case may be, together with an affidavit verifying such certificate. So you've got to have the certificate in writing with an affidavit as well, I think, by the looks of it. And such court or judge shall thereupon immediately stay such civil or criminal proceedings. So this says they've got to comply with it. And this was before that Parliament Act 1911 it says that Speaker's certificate shall not be doubted in a court of law. Criminal proceedings and the same, and every writ or process issued therein shall be and shall be deemed and taken to be finally put an end to, determined and superseded by virtue of this act. It's actually by virtue of this act, but not by virtue of the certificate, right? It's actually this act of law that ceases all proceedings, right? It's not actually the privilege of Parliament. It's the actual certificate of an affidavit, but they aren't to be doubted. After 1911, they cannot be questioned or doubted, but this act says that they've got to be complied with anyway. Oh no, it says the Speaker's certificate cannot be questioned in a court of law, but this one doesn't. This doesn't have to be from the Speaker. It can be from the clerk or Chancellor, etc. It only says that the Speakers can't be doubted. It doesn't say the Chancellors or the Keeper of the Seal, whatever it is. So, and then we've got these other two parts. And be enacted that in case of any civil or criminal proceedings hereafter to be commenced or prosecuted on account or in respect to the publication of any copy of such report, paper, votes or proceedings that shall be lawful for the defendant or defendants at any stage or proceedings to lay before the court or judge such report, papers, votes or proceedings and such copy with an affidavit verifying such report, paper, votes or proceedings and the correctness of such copy. All right, just a minute. Application of any copy of such report paper versus proceedings, it shall be lawful for the defendant or defendants at any stage of the proceedings to lay before the court or judge such report papers, votes, or proceedings. Well, that could be a petition then, right? And such copy with an affidavit verifying such report paper, votes, or proceedings and the correctness of such copy, and the court or judge shall immediately stay such civil or criminal proceedings, and the same and every writ or process issued therein shall be deemed and taken to be finally put an end to and deemed to. So, just a minute, any paper document of proceedings, etc., is your actual petition. That's the thing. So, I actually don't even believe that I missed this part out of it, right? According to this, it says that if you put an affidavit in front of it, and this is not one actually, this is a different separate section, this, right? This is not actually the certificate, this part. This is like if you actually present an affidavit. But this is the thing. Your petition has got the petition itself, right? The petition, or even bill it was called, but it could be called bill or a petition. In the standing orders, it says it contains allegations, right? Affidavits contain allegations. So, and this section here is not actually one that's necessarily written by the Speaker or Chancellor or Privy Seal or Clerk. So, according to this, if you actually show your petition, such a manifest the proceedings, right? But only to do with like criminal and civil charges concerning the publication of papers, right? So, in my case, it would not have protected me from the dangerous driving charge, right? Because it was for, I was going about collecting evidence for my case, right? Not, it wasn't to do with the canvassing of it and the publication of the papers, right? It wasn't like advertising my petitioning cause and collecting signatures. I was collecting evidence, right? But evidence that actually does go into the petition evidence. But this can't be used for that. It can only be used for the canvassing part of it, right? And the sharing of the information and advertisements, making it known and available to the public, right? But that can be for, like, you know, obscene publications or anything like that. There are a number of criminal charges. Criminal damage can fall under it if it is for in connection with, like, you know, putting notices and signs up, because the police are incorrectly prosecuting people with criminal damage when it's defacement, and the defacement is because you're putting signs and notices up and things like that, right? That can come under it. In fact, there's more of an argument for the installation of models or transformation into models of the ULEZ cameras to advertise like Stop ULEZ. That's more arguable under this if you've got the right argument like me and you know how to make it, right? Under modern laws, under the definition of advertisements, right? That's more arguable under this than, you know, me for my dangerous driving charge. But my previous charges, right, one of them was for they charged me with criminal damage, etc., or putting signs by the highway, right? That's canvassing and advertisement promotion, right? And that would have fallen under this, putting stickers on, you know, street furniture and things like that, because that's advertising the handbills and advertisements and so forth in public, right? So my proceedings should have been stayed or stopped when I was in the Magistrates Court in Manchester on the basis of this act, right? And I specifically remember when I was in the, interview room with one of the duty solicitors, and I was giving him all my parliamentary stuff, and he was kind of all right, but I just didn't know enough. And then one of the Crown prosecutors mentioned the Bill of Rights, but, so what? He didn't mention it in context to, application or anything like that. And the judge, I'm sure that guy was Peter Fahey, but I can't prove that. But the judge was almost like a Peter Fahey lookalike, if I've ever seen one, right? And they just basically fobbed me off in the courtroom. And if I'd have had this and known this now, like I do now, my actual petition itself, because my petition is actually a national investigation, concerning unlawful acts of the government. So it isn't that the petition itself is the affidavit in a way, really, because that's what the police themselves submit affidavits to court. So it is like an affidavit to Parliament. This section here doesn't actually say that the affidavit has to be written or issued by the Speaker or any of the ministers or the clerk. It says that the affidavit and papers, so you can have the petition and your petition adverts, so the papers that go with the actual petition itself, right? So I should have been able to actually use that in Manchester. And be it enacted that it shall be lawful in any civil or criminal proceedings to be commenced or prosecuted for printing any extract from or abstract of such report, paper, votes or proceedings to give in evidence under the general issue. So it's also general, it's talking about general issue as well. Such report. So, you see, general issue, that, this is what gets me, right? The government and police are trying to pitch under the Public Order Act that you can't have general political protest, right? That, it can't be attached to a cause. But here, it's saying that you can have, under a general issue, right, these exemptions and protections under your general issue, and also abstracts of reports and things like that. So that's more like these protests that it's, like the farmers' rally, the farmers' demonstrations. We know that they've got causes and matters to Parliament and there are petitions running for it and they're trying to raise awareness of it. It's the general issue, right? And they've got advertisements for it, and on the farmers' tax, well, that's what the issue is. The farmers' tax is the general issue. Such report seems to show that such extract or abstract was published bona fide and without malice. So that bottom bit there, that's like what those Mandela versus Wright case or whatever it is that's in that Carl Witch book's talking about, all those legal case outcomes. And then here, provided always, and it is hereby expressly declared and enacted that nothing herein contained shall be deemed or taken or held or construed directly or indirectly by implication or otherwise to affect the privileges of Parliament in any matter whatsoever. So basically it means that no court, judgment, order or anything like that can set or make or change a precedent in law through the country that will somehow set some permanent effect or change to the privileges of Parliament, because the courts cannot do that. Only Parliament can decide what the privileges are, right? So instead, they've sort of made this act. So according to this now, what's the title of this part? Act not to affect the privilege of Parliament. Right, so according to this, I'm pretty sure now this second section. I don't know why the 1841 says Speaker of the Lords, because I didn't think that they had an official Speaker of the Lords until they had the Constitutional Reform Act. So I'm a bit puzzled with that, because I thought that this, the older one, didn't have the Speaker of the Lords in, and the newer one did. But I know the newer one's made to be compatible with the Broadcasting Act 1990. Seems to be stayed when commenced in respect of a copy of an authenticated. Well, the thing is, the e-petitions are authenticated, aren't they? The actual e-petitions themselves are authenticated because they're actually on the Parliament website, and they've been verified, and they're authenticated by the Crown Copyright, right? Because it's actually the legitimate website. So those e-petitions actually are authenticated. They are authenticated. But this really will only protect you in, like, canvassing issues if you're, sticking, plastering, notices and posters up and things like that. There is an argument to stretch it to some of the installation stuff on, like, the ULEZ cameras, but, the courts don't like that part of it. But that is, that exists, that argument. You can actually use the petitions themselves. But I wouldn't have been able to use it for my dangerous driving charge. But what it does do is it shows that there is actually this thing, right? It exists. There is this sort of protection from criminal and civil charges for doing these type of things. And if it applies to canvassing signs and notices and things like that, then... And if this isn't actually getting, if this itself isn't the privilege of Parliament, what happens when you are claiming the actual full privilege of Parliament, and it's like in the 1688 Bill of Rights straight off the page, right? So this is like, the shoehorn into the whole thing, that there actually is this whole thing and it exists, and it's not a load of fabricated rubbish, right? So I'm actually quite surprised that I hadn't clocked onto that bit earlier before. That second paragraph there. Hold on. You see, look, right? This here says that the office of the Lord Speaker was created in 2006 following the Constitutional Reform Act. I said that. I just told you that, right? The first election of the position took place on July the 4th, 2006. So I don't know what the 1840 Act is saying, because I thought that they only updated it to Lord Speaker in the amended version when they updated it with the, later on, with the Broadcasting Act 1990. So it has got the Speaker of the House. I thought the Speaker of the House of Lords was only in this new one, right? But apparently... the Speaker of the House of Lords